You think this is funny, Mr. Harrington? Do you think this courtroom is a stage for your entertainment? 17-year-old Brandon Harrington smirked at Judge Patricia Thornton from the defense table, his posture deliberately slouched, his expression radiating contempt as the judge read the charges against him. The murder of 16-year-old Ethan Webb, his former best friend, had shocked the affluent community of Lakewood, Illinois. But what disturbed courtroom observers even more was Brandon's complete lack of remorse throughout the proceedings. He whispered jokes to his attorneys during victim impact statements, rolled his eyes at witness testimony, and, at one point, had actually laughed when the medical examiner described Ethan's final moments. What Brandon Harrington didn't anticipate was that his own mother, Patricia Harrington, a respected family law attorney who had initially stood by her son unconditionally, would rise from the gallery during his sentencing hearing to deliver testimony that would destroy his defense strategy and ensure he would never walk free again. Before we continue with this extraordinary case, I'd like to ask you to subscribe to our channel if you haven't already. Let us know in the comments where you're watching from as we explore this disturbing case of teenage violence, misplaced privilege, and a mother's impossible choice between protecting her son and honoring the truth. The town of Lakewood, Illinois, represented the American upper-middle-class ideal in nearly every measurable way. Located 30 miles northwest of Chicago, this community of approximately 45,000 residents boasted excellent public schools, tree-lined streets with meticulously maintained Victorian and colonial homes, a vibrant downtown with boutique shops and farm-to-table restaurants, and crime rates that ranked among the lowest in the state. The high school graduation rate exceeded 95%, with the majority of graduates attending four-year universities. Lakewood High School's academic and athletic programs consistently won state recognition, and the community took pride in the careful balance between achievement and well-being that defined their approach to raising children. It was in this environment of privilege and expectation that Brandon Harrington and Ethan Webb had grown up as neighbors and best friends since kindergarten. Their families lived on Willow Creek Lane, an especially affluent street where homes exceeded 7 figures and professional landscaping maintained the appearance of effortless perfection. The Harrington family occupied a sprawling Tudor-style home at the corner of Willow Creek and Oak Ridge, while the Webb family's modern farmhouse-style residence sat 3 houses down, close enough that the boys had worn a path through backyards during their childhood years of constant companionship. Ethan David Webb was everything Lakewood valued in its young people. At 16 years old and a junior at Lakewood High School, Ethan maintained a 4.2 GPA while serving as captain of the debate team, playing varsity lacrosse, and volunteering weekly at the Lakewood Community Food Pantry. Teachers described him as genuinely kind, intellectually curious without being arrogant, and possessed of an emotional intelligence unusual for his age. His debate coach, Margaret Sullivan, would later tell investigators that Ethan had a gift for understanding multiple perspectives on complex issues, making him not just a formidable debater, but also a natural mediator among his peers. Ethan's parents, David and Sarah Webb, were both physicians who had met during their residencies at Northwestern Memorial Hospital in Chicago. David practiced cardiology at Lakewood Medical Center, while Sarah had recently transitioned from clinical pediatrics to medical education, teaching at the University of Illinois College of Medicine. The Webbs were known in the community as warm and engaged parents who hosted annual block parties, supported local charities, and had maintained a close friendship with the Harrington family for nearly 2 decades. Behind Ethan's impressive resume of achievements lay a genuinely thoughtful and principled young man. His younger sister, Maya, who was 13 at the time of his death, would later describe him as the person I wanted to be like when I grew up. She recalled how Ethan had spent hours helping her with homework, how he had confronted bullies at school who had been targeting her friend, and how he had saved money from his summer job to buy her a guitar she wanted, but the family couldn't justify purchasing. Ethan's journals, recovered after his death and submitted as evidence during Brandon's trial, revealed a teenager grappling with typical adolescent concerns while maintaining an unusual degree of self-awareness. One entry from September 2023, approximately 2 months before his murder, demonstrated his reflective nature. College application season is making everyone crazy. Brandon especially seems stressed, though he won't talk about it. I know he's worried about living up to his parents' expectations, particularly his mom's. Sometimes I think being the son of 2 successful lawyers is harder than being the son of 2 doctors, because at least my parents understand that medicine requires genuine passion, not just good grades. Brandon's parents seem to view everything as a competition, even things that shouldn't be competitions. This observation proved tragically prescient, as the mounting academic and social pressures on Brandon Harrington would become central to understanding the motivations behind Ethan's murder. What Ethan couldn't have known as he wrote that entry was that his own academic success and seemingly effortless navigation of the pressures they both faced had become a source of intense resentment for his best friend, a resentment that would ultimately turn lethal. Brandon Michael Harrington presented a starkly different personality, despite sharing many of the same external advantages as Ethan. The only child of Thomas and Patricia Harrington, both prominent attorneys in Chicago, Brandon had grown up in an environment defined by achievement, competition, and the unspoken expectation that success was not just encouraged, but required. Thomas Harrington was a senior partner at a prestigious corporate law firm, known for his aggressive litigation style and his record of securing 8-figure settlements for clients. Patricia Harrington had built a successful family law practice representing high-net-worth clients in complex divorce and custody proceedings, earning a reputation for being both brilliant and ruthless in protecting her clients' interests. The Harrington household, while materially abundant, operated on principles markedly different from the Webb family's approach to parenting. Excellence was expected, and anything less was treated as failure, requiring explanation and correction. Brandon's childhood had been structured around activities designed to build impressive college applications. Piano lessons from age 5, competitive swimming, debate team, Model UN, and summer enrichment programs at Northwestern University. His parents' approach to his education was characterized by constant monitoring, regular meetings with teachers to discuss his performance, and private tutors for any subject where he showed less than perfect mastery. By his junior year of high school, Brandon maintained a 3.9 GPA, played on the varsity lacrosse team alongside Ethan, and held leadership positions in several extracurricular activities. To outside observers, he appeared to be thriving, another Lakewood success story. But beneath this polished exterior, Brandon was struggling with increasing depression, anxiety, and a growing sense that he would never measure up to the standards his parents had set. More troublingly, he had begun to attribute his feelings of inadequacy not to his parents' unrealistic expectations, but to Ethan's existence as a constant point of comparison. School counseling records, which became crucial evidence during the investigation, revealed that Brandon had been seeing the school psychologist since his sophomore year, primarily for anxiety management. In one session from October 2023, Brandon had told the counselor, "Everyone always compares me to Ethan. Teachers, parents, other kids. He makes everything look easy, and it makes me look like I'm not trying hard enough. Even my own parents hold him up as an example of what I should be doing. They don't say it directly, but I can tell they wish I was more like him." The counselor's notes indicated concern about Brandon's increasingly external locus of control and his tendency to blame others for his feelings of inadequacy. The counselor had recommended that Brandon see a psychiatrist for evaluation and possible medication for depression and anxiety, a recommendation that Patricia Harrington had rejected, telling the counselor that her son didn't need to be labeled with a mental illness and that he simply needed to work harder and develop better coping skills. This rejection of professional mental health intervention would later become a point of significant regret for Patricia Harrington and would feature prominently in her eventual testimony against her son. The counselor's detailed notes documenting these interactions and Patricia's refusal to pursue psychiatric care would be used by prosecutors to demonstrate that warning signs had been present and ignored, that Brandon's deteriorating mental state had been observable to professionals, and that the family's emphasis on maintaining appearances had taken precedence over addressing serious psychological concerns. The friendship between Brandon and Ethan, which had been close and apparently genuine throughout childhood, began showing signs of strain during their junior year of high school. Several incidents documented by school personnel, fellow students, and social media posts revealed a relationship transforming from friendship to rivalry, at least from Brandon's perspective. Ethan, according to all accounts, remained unaware that his best friend was beginning to view him as an adversary rather than an ally. The first significant public conflict occurred in early October 2023, during a lacrosse team meeting. Both Brandon and Ethan were competing for a starting position, and when the coach announced that Ethan would start while Brandon would serve as backup, Brandon had responded with visible anger. Multiple teammates recalled him muttering loud enough to be heard, "Of course, perfect Ethan gets everything he wants." When Ethan attempted to talk to Brandon after practice, trying to reassure him that the coach's decision didn't diminish his abilities, Brandon had responded with hostility, telling Ethan to stop pretending to care and accusing him of fake humility. The second incident occurred in late October during a debate team competition. Both students were competing in the Lincoln Douglas debate category, and both made it to the final round where they debated each other. Ethan won the competition, and Brandon's reaction disturbed both the debate coach and several parents in attendance. Rather than congratulating his friend and competitor, Brandon had thrown his notes on the floor, walked out of the auditorium without shaking Ethan's hand as protocol required, and was later found in his car punching the steering wheel repeatedly while crying. Margaret Sullivan, the debate coach, had immediately reported this incident to school administrators and had attempted to speak with Brandon about his reaction. In her incident report, she wrote, "Brandon's response was completely disproportionate to the situation. Losing a debate round, even a final round, is a normal part of competition. His rage suggested this was about something much deeper than the debate itself. When I tried to discuss it with him, he became defensive and blamed Ethan for showing off and trying to humiliate him in front of everyone. I recommended that the school counselor follow up, as this level of emotional dysregulation concerns me." The third and most ominous incident occurred in mid-November 2023, just 2 weeks before Ethan's murder. Brandon had applied early decision to Northwestern University, his parents' alma mater and his first-choice school. Ethan had also applied to Northwestern, though he had not applied early decision and was considering several other universities as well. When Brandon learned through the school grapevine that several teachers had written letters of recommendation for Ethan, describing him in glowing terms, while his own recommendation letters were reportedly more moderate in their praise, he had confronted Ethan in the school parking lot. Multiple witnesses, including several students who recorded portions of the confrontation on their phones, documented Brandon shouting at Ethan, accusing him of sabotaging his college applications and turning teachers against him. Ethan, visibly confused and upset by the accusations, had tried to calm Brandon down, explaining that he had nothing to do with what teachers wrote in their recommendation letters, and that he wanted both of them to get into their top choice schools. Brandon's response, captured on video and later played during trial, was chilling in retrospect. "You think you're so perfect, don't you? You think you deserve everything, but you don't. You don't deserve any of it. And one day, everyone is going to see who you really are." The school administration had responded to this incident by requiring Brandon to meet with the school counselor and temporarily suspending him from extracurricular activities, pending a psychological evaluation. Patricia Harrington, in her capacity as an attorney and parent, had threatened the school with legal action if they proceeded with requiring a psychological evaluation as a condition for Brandon's return to activities. After consultation with the district's legal counsel, the school had backed down, allowing Brandon to return to activities after a brief suspension and several meetings with the school counselor, who was prohibited from requiring external evaluation without parental consent. This pattern of escalating hostility culminated on the evening of November 28, 2023, when Brandon Harrington murdered Ethan Webb in a premeditated attack at the Lakewood Community Nature Preserve. The events of that night would be reconstructed through a combination of physical evidence, digital forensics, witness testimony, and eventually Brandon's own statements, creating a detailed timeline of calculated violence that belied any defense claims of impulsivity or accident. The Nature Preserve, a 200-acre area of protected woodland and wetland on the outskirts of Lakewood, featured several miles of hiking trails popular with local residents. The preserve was generally safe, well-maintained, and regularly patrolled by park rangers during daylight hours, though it closed officially at sunset. The parking lot, which could accommodate about 30 vehicles, had security cameras monitoring vehicle entry and exit, though the trails themselves were not under surveillance. On the afternoon of November 28th, Brandon sent Ethan a text message suggesting they meet at the nature preserve that evening to talk about everything that's been going on. The text, recovered from Ethan's phone, read, "Hey man, I know I've been a jerk lately. You're right that I've been stressed about college and taking it out on you. Can we meet at the nature preserve tonight around 7? Want to clear the air and apologize properly. I miss my best friend." This message, which Ethan showed to his mother before leaving the house, seemed to indicate that Brandon was seeking reconciliation, and Sarah Webb had encouraged her son to go, believing the friendship was worth salvaging. What the text message didn't reveal was that Brandon had been planning an attack on Ethan for at least several days, possibly longer. Digital forensics would later recover search history from Brandon's laptop, showing he had researched the nature preserve's camera coverage, sunset times, and patterns of park ranger patrols. He had searched for information about which areas of the preserve were most isolated, and had even looked up the route Ethan typically jogged, suggesting he had been gathering information for a calculated attack. More disturbing were searches related to methods of killing and body disposal that Brandon had conducted in the week before the murder. His search history included: how long does it take to die from blunt force trauma to head? Do park security cameras record 24/7 or motion activated? How to clean blood from clothes? How long until someone is found in woods? And can deleted text messages be recovered by police? These searches, time-stamped and preserved through forensic examination, would become cornerstone evidence of premeditation. On the evening of November 28th, Brandon arrived at the Nature Preserve parking lot at 6:45 p.m., 15 minutes before the agreed meeting time. Security camera footage showed his car, a black BMW sedan his parents had given him for his 16th birthday, pulling into a parking space in the far corner of the lot, away from the entrance and the camera's best coverage. Brandon exited the vehicle carrying what appeared to be a backpack and walked toward the trailhead leading to the preserve's interior. Ethan arrived at 7:02 p.m., parking his older Toyota Camry near the entrance where the light-in was better. He appeared alone, carrying no bag or equipment, simply dressed in jeans and a hoodie suitable for a cool November evening. Security footage showed him checking his phone, presumably looking at Brandon's text, before walking toward the same trailhead Brandon had taken minutes earlier. This would be the last time Ethan Webb was seen alive on any recording. What occurred in the woods over the next 35 to 40 minutes would be reconstructed through forensic evidence, Brandon's eventual inconsistent statements, and the testimony of Dr. Robert Chen, the medical examiner who performed Ethan's autopsy. Based on this evidence, investigators determined that Brandon had waited for Ethan on a section of trail known as the Oak Ridge Loop, approximately half a mile from the parking lot, in an area particularly isolated and far from any other trails. When Ethan reached the predetermined meeting spot, Brandon attacked him from behind, using a metal baseball bat he had concealed in his backpack. The first blow struck Ethan on the back of his head, causing immediate disorientation and collapse. Medical examination would later show that this initial blow had fractured Ethan's skull and caused significant brain trauma, though it had not immediately killed him. Brandon then delivered at least 6 additional blows to Ethan's head and upper body, creating injuries that the medical examiner would describe as demonstrating rage and continuation of attack long after victim was incapacitated. After the attack, Brandon attempted to drag Ethan's body off the trail into denser undergrowth, leaving a clear trail of disturbed vegetation and blood evidence that forensic teams would later follow. He partially concealed the body under leaves and branches in what investigators later described as a hasty and ineffective attempt at concealment. Brandon then collected the baseball bat, which was now covered in blood and hair, placed it back in his backpack, and returned to his car, exiting the parking lot at 7:51 p.m. according to security camera timestamps. The security footage of Brandon leaving the preserve would prove particularly damning during trial. Rather than appearing panicked or disturbed, Brandon looked calm and composed. He walked at a normal pace, checked his phone casually while approaching his car, and drove away at a moderate speed that suggested no urgency or distress. This demeanor, so at odds with what would be expected from someone who had just killed their best friend in a violent attack, would later support the prosecution's characterization of Brandon as a calculated killer without remorse. Ethan's body was discovered the following morning, November 29th, by a park ranger conducting a routine trail inspection before the preserve opened to the public. Ranger Thomas Martinez, a veteran of 15 years with the Lakewood Park District, came across the body at approximately 7:15 a.m. while walking the Oak Ridge Loop Trail. His 911 call, placed at 7:17 a.m., conveyed both his professional training and his genuine shock at finding a deceased teenager in the preserve's normally peaceful environment. This is Ranger Martinez at the Lakewood Nature Preserve. I found a body on the Oak Ridge Loop Trail, approximately half a mile from the main parking area. Male, appears to be a teenager, significant head trauma, obviously deceased. I need police and medical examiner immediately. This is clearly a crime scene, not an accident. Martinez's training had taught him to secure the area without disturbing evidence, and he remained at the scene, using his radio to contact other rangers to close the preserve and prevent any other visitors from accessing the trails while he waited for law enforcement to arrive. Detective Marcus Thompson of the Lakewood Police Department was the first investigator on scene, arriving at 7:34 a.m., along with patrol officers who had responded to the initial call. Thompson, a 20-year veteran of the force with extensive training in homicide investigation, immediately recognized that the victim was likely a local teenager based on his clothing and appearance. The presence of significant blood evidence at the scene, the obvious trauma to the victim's head and body, and the attempt to conceal the body under foliage all indicated this was a homicide rather than an accidental death or medical emergency. As crime scene technicians began documenting and processing the area, Detective Thompson conducted a preliminary examination of the victim's belongings. Ethan's wallet, found in his jeans pocket, contained his driver's license, immediately identifying him as Ethan David Webb, age 16 of Willow Creek Lane in Lakewood. His phone, also recovered from his pocket, had sustained damage during the attack but was immediately secured for forensic examination. Thompson made the notification call to David and Sarah Webb at 8:47 a.m., arriving at their home shortly thereafter to deliver the news in person. The Webbs' reaction, described in Thompson's report as devastation consistent with genuine shock and grief, eliminated them as potential suspects and began what would become their nightmare journey through the criminal justice system. When Thompson asked about Ethan's plans the previous evening, Sarah Webb immediately mentioned that Ethan had gone to meet Brandon Harrington at the nature preserve, showing the detective the text message Ethan had shown her before leaving. This information immediately focused the investigation on Brandon Harrington, and Detective Thompson obtained security footage from the Nature Preserve's parking lot while driving to the Harrington residence to conduct an initial interview. The footage, reviewed while en route, confirmed that both Ethan and Brandon had been at the preserve during the time frame when the murder occurred, with Brandon arriving first and leaving approximately 50 minutes after Ethan's arrival. This timeline gave Thompson probable cause to treat Brandon as the primary suspect rather than simply a witness. The Harrington household, when Detective Thompson and his partner arrived at 10:23 a.m., presented a scene of apparent normalcy that would soon be shattered. Patricia Harrington, working from home that morning, answered the door in professional attire, having been on a conference call with clients moments earlier. When Thompson explained that he was investigating an incident at the nature preserve and needed to speak with Brandon about his meeting with Ethan Webb the previous evening, Patricia's attorney instincts immediately activated, and she asked why police needed to speak with her son about a nature preserve incident. Thompson's response was carefully calibrated to gauge reaction while providing minimal information. Ethan Webb was found deceased at the preserve this morning. We're speaking with everyone who was at the preserve last evening, and we have security footage showing Brandon's vehicle in the parking lot. We need to establish a timeline of events. Patricia Harrington's reaction to learning of Ethan's death, described by Thompson as appropriate shock followed quickly by professional guardedness, was markedly different from the Webb family's raw grief. Patricia immediately stated that Brandon would not be speaking with police without legal representation present, a decision that was her right as a parent and attorney, but one that Detective Thompson noted as potentially significant. Most innocent witnesses, particularly those with information about a friend's death, are eager to help police, not immediately lawyering up before any questions are even asked. However, Thompson professionally acknowledged Patricia's right to legal counsel and asked if Brandon was home so they could at least confirm his well-being. Brandon was located in his bedroom, reportedly having slept in late after telling his parents he was tired from a late night of studying. When informed by his mother that Ethan had died and that police wanted to speak with him, Brandon's reaction would later be described by Detective Thompson as remarkably composed for a teenager learning of his best friend's death. Rather than displaying grief, shock, or even asking what happened, Brandon's first response was to ask if he needed a lawyer. This response, combined with Patricia Harrington's immediate invocation of legal counsel before any questions were asked, meant that investigators would need to build their case through forensic evidence and digital forensics rather than through interview and interrogation. Thompson left the Harrington residence at 10:47 a.m., having accomplished nothing more than confirming that Brandon was home and physically unharmed, but having observed reactions that strengthened his suspicions that Brandon was involved in Ethan's death. The investigation that unfolded over the next 72 hours combined traditional detective work with cutting-edge digital forensics and meticulous crime scene analysis. The evidence that emerged created an overwhelming case against Brandon Harrington, demonstrating not only that he had killed Ethan Webb, but that he had planned the murder in advance and had shown no remorse afterward. The crime scene analysis yielded multiple crucial pieces of evidence. Blood spatter patterns documented by forensic specialists showed that Ethan had been attacked in the location where his body was found, not killed elsewhere and moved to the preserve. The pattern of blood on the ground and surrounding vegetation was consistent with multiple blunt force blows delivered while the victim was on the ground. Investigators located several areas of disturbed soil and foliage where it appeared someone had attempted to cover or drag the body, and these areas yielded shoe impressions that matched a distinctive pattern. The shoe impressions, photographed and cast by crime scene technicians, would later be matched to a pair of Nike running shoes found in Brandon Harrington's bedroom during execution of a search warrant. The shoes, which Brandon had apparently attempted to clean, still showed traces of blood in the tread pattern. DNA analysis would later confirm that this blood belonged to Ethan Webb, providing a direct physical link between Brandon and the crime scene. The murder weapon, while not located at the scene, was discovered during the search of Brandon's car and bedroom. In the trunk of Brandon's BMW, wrapped in a garbage bag and covered with camping equipment, investigators found an aluminum baseball bat with visible blood staining despite obvious cleaning attempts. The bat, a Louisville Slugger model that Brandon's parents confirmed he had owned since middle school, bore blood evidence that DNA testing matched to Ethan Webb. More significantly, the pattern of blood distribution on the bat, analyzed by forensic experts, matched the impact patterns found on Ethan's skull and body, conclusively establishing this bat as the murder weapon. Digital forensics provided the most comprehensive evidence of premeditation. Ethan's phone, while damaged, yielded recoverable data that showed the text exchange between him and Brandon arranging the meeting. The forensic examination revealed that the messages had been sent from Brandon's phone, establishing that he had initiated the meeting that led to Ethan's death. More significantly, the phone's location data showed that Ethan had arrived at the preserve at 7:02 p.m., and that his phone had stopped transmitting location data at 7:38 p.m., establishing the approximate time of death. Brandon's phone and laptop, seized during execution of search warrants, provided even more damaging evidence. The search history documenting his research about the preserve, security cameras, and methods of killing created a clear picture of planning and preparation. Text messages between Brandon and his parents on the night of the murder showed him returning home around 8:15 p.m., and claiming he had been at the library studying. A lie that the security footage from the preserve and the library, which showed he had not been there, would easily disprove. Most damning was Brandon's online activity in the hours after murdering Ethan. Rather than showing distress or concern about his friend's absence, Brandon had spent the evening of November 28th gaming online, chatting normally with other players, and completing homework assignments. He had posted to social media at 10:47 p.m. with a photo of his dinner captioned, "Perfect end to a productive day," showing no indication that anything unusual had occurred. This evidence of normal, even upbeat behavior immediately after committing murder would become central to the prosecution's argument that Brandon was a calculating killer without conscience or remorse. On December 1st, 2023, 72 hours after Ethan's body was discovered, Detective Thompson and prosecutors from the DuPage County State's Attorney's Office obtained an arrest warrant for Brandon Harrington, charging him with first-degree murder. The decision to charge Brandon as an adult, despite his being 17 at the time of the murder, was made after consultation with juvenile justice authorities, who determined that the premeditated nature of the crime, the level of violence involved, and the evidence of planning warranted adult prosecution. The arrest took place at the Harrington residence at 7 a.m. on December 1st. Brandon was taken into custody without incident, though his behavior during the arrest raised eyebrows among the officers present. Rather than showing fear, anxiety, or even surprise at being arrested for murder, Brandon appeared almost amused, smirking at officers and making jokes about the handcuffs being uncomfortable. One officer later testified that as Brandon was being placed in the patrol car, he had said, "This is ridiculous. My parents' lawyers will have me home by dinner." This confident prediction of a quick release demonstrated Brandon's fundamental misunderstanding of the severity of his situation and the strength of the evidence against him. It also revealed an attitude of entitlement and invincibility that would characterize his behavior throughout the legal proceedings, and would ultimately contribute to his undoing at sentencing. The Odge arraignment, held on December 4th, 2023, provided the first public glimpse of Brandon's disturbing courtroom demeanor. Represented by Charles Morrison, a high-priced criminal defense attorney retained by his parents, Brandon entered a plea of not guilty to first-degree murder charges. His behavior during the arraignment shocked courtroom observers and local media representatives who were covering what had already become the most significant criminal case in Lakewood's recent history. Brandon appeared completely unbothered by the proceedings, at one point yawning visibly while the judge read the charges against him, and whispering to his attorney in a way that appeared casual and unconcerned, rather than fearful or serious. When Judge Patricia Thornton asked if he understood the charges, Brandon responded with, "Yeah, I understand them. I just don't agree with them," delivering the statement with a smirk that suggested he viewed the entire proceeding as an inconvenience, rather than a matter potentially determining the rest of his life. Judge Thornton, a 15-year veteran of the bench known for her no-nonsense approach to criminal proceedings, responded sharply to Brandon's attitude. "Mr. Harrington, I suggest you adjust your demeanor. This is not a joke, and this courtroom is not a place for your entertainment. You stand accused of murder. I recommend you treat these proceedings with the gravity they deserve." Brandon's response was to shrug and look away, an action that prompted his attorney to lean in and whisper urgently to him, presumably advising him to show more respect. The bond hearing that followed the arraignment revealed additional aspects of Brandon's character that troubled both the judge and prosecutors. The defense argued for reasonable bail, noting Brandon's lack of criminal history, his strong ties to the community, and his family's willingness to ensure his appearance at trial. The prosecution countered with the severity of the charges, the strength of the evidence, and Brandon's apparent lack of remorse as demonstrated by his behavior since arrest. During the prosecutor's argument about Brandon's lack of remorse, Brandon was observed by multiple court personnel to be rolling his eyes and shaking his head, as if the prosecutor's characterization was absurd rather than accurate. When the prosecutor referenced Brandon's social media post from the evening of the murder, calling it a disturbing glimpse into the mind of someone who could kill his best friend and then post about having a productive day, Brandon actually laughed loud enough to be heard throughout the courtroom. Judge Thornton, her patience clearly exhausted, addressed Brandon directly. "Mr. Harrington, do you find something amusing about these proceedings?" Brandon, seemingly unable to read the seriousness of the moment, responded, "I just think this whole thing is being blown out of proportion. People are acting like I'm some kind of monster, and it's just not accurate." This statement, made in open court and recorded by court reporters, would be played repeatedly during the trial and referenced extensively in media coverage of the case. Judge Thornton set bail at $2 million, an amount that, while high, the Harrington family was able to post through a combination of property bonds and their considerable financial resources. Brandon was released from custody on December 6, 2023, pending trial with conditions including GPS monitoring, surrender of his passport, prohibition from leaving Illinois, and complete prohibition from any contact with the Webb family or potential witnesses in the case. Brandon's behavior during the months between his arraignment and trial continued to demonstrate a shocking lack of understanding about his situation. Social media posts from accounts belonging to his friends showed Brandon attending parties, playing video games, and generally continuing his life as if he were not facing a murder charge that could result in life imprisonment. While he was smart enough not to post about the case directly on his own accounts, his presence in other people's photos and videos, often smiling and appearing carefree, created a public relations nightmare for his defense team. More problematic were reports from multiple sources that Brandon had been making inappropriate comments about the case to friends and acquaintances. Several of his classmates, interviewed by prosecutors preparing for trial, reported that Brandon had described the legal proceedings as a joke, predicted that his parents' money and attorneys would make this go away, and even made light of Ethan's death, at one point reportedly saying, "Ethan always wanted to be remembered. Well, now he will be." These comments, related to prosecutors through witness statements, painted a picture of a defendant completely lacking in remorse, empathy, or understanding of the gravity of his situation. However, they presented a challenge for the prosecution because many of them could not be presented as direct evidence due to hearsay rules. The witnesses could testify to what Brandon had said in their presence, but second-hand reports of his statements would generally not be admissible unless they met specific exceptions to the hearsay rule. The psychological evaluation of Brandon Harrington, ordered by the court to assess his competency to stand trial and his mental state at the time of the offense, revealed a complex and disturbing personality profile. Dr. Jennifer Walsh, a forensic psychologist with extensive experience evaluating juvenile offenders, spent over 20 hours with Brandon across multiple sessions, administering psychological tests, conducting clinical interviews, and reviewing his educational, medical, and social history. Dr. Walsh's report, submitted to the court in February 2024, found Brandon competent to stand trial, meaning he understood the charges against him, could assist in his own defense, and comprehended the nature of the proceedings. However, the evaluation also documented significant personality features that helped explain his behavior while raising serious questions about his capacity for empathy and remorse. The psychological testing revealed elevated scores on measures of narcissism, entitlement, and lack of empathy. Brandon scored particularly high on the Narcissistic Personality Inventory, showing characteristics including grandiose sense of self-importance, preoccupation with fantasies of success and power, belief in his own superiority, sense of entitlement, and lack of empathy for others. The evaluation noted that while these traits fell short of a formal diagnosis of narcissistic personality disorder, they represented significant character features that influenced his behavior and relationships. Dr. Walsh's report described Brandon's presentation during the evaluation sessions. The subject displayed consistent patterns of minimization, externalization of blame, and lack of emotional depth when discussing the offense. When asked about his relationship with the victim, he focused primarily on ways the victim had supposedly wronged him or made his life difficult, showing little capacity to view the situation from the victim's perspective. When asked directly about his feelings regarding the victim's death, the subject stated, "I feel bad that it happened, but honestly, I feel worse about how this is affecting my life and my future." The evaluation also examined Brandon's family dynamics and their potential contribution to his psychological development. Dr. Walsh noted that the Harrington household's emphasis on achievement, competition, and external validation, combined with apparent lack of emphasis on emotional development and empathy, had likely contributed to Brandon's narcissistic features and his inability to regulate emotions when faced with threats to his self-image. The subject was raised in an environment where worth was equated with achievement, and where vulnerability or emotional expression was implicitly discouraged, Dr. Walsh wrote. He learned to derive self-esteem entirely from external validation and comparison to others, creating a fragile sense of self that required constant reinforcement. When faced with a peer who consistently outperformed him, the subject experienced this not as normal competition but as an existential threat to his self-concept. The evaluation's conclusion addressed the question of whether Brandon's psychological features constituted a mental illness that would affect criminal responsibility. While the subject displays significant personality features that help explain his behavior, these do not rise to the level of mental illness or defect that would impair his ability to understand right from wrong or to conform his behavior to the requirements of law. The subject understood that killing the victim was wrong, planned the offense to avoid detection, and took steps afterward to conceal his involvement. These actions demonstrate rational thinking and understanding of legal and moral consequences, even if his emotional response to his actions is significantly impaired. This evaluation would become crucial during trial, as the defense attempted to use Brandon's psychological features to argue for reduced culpability, while the prosecution used the same evaluation to demonstrate that Brandon had the mental capacity to plan and execute murder while understanding that his actions were wrong. The months leading up to trial also saw significant developments in the relationship between Brandon and his mother, Patricia Harrington. Initially, Patricia had stood firmly behind her son, maintaining his innocence despite the mounting evidence, hiring the best legal representation money could afford, and making public statements expressing confidence that the truth would exonerate Brandon. However, as discovery proceeded, and Patricia gained full access to the evidence through her son's defense team, her certainty began to waver. Patricia's evolution from defensive mother to reluctant witness for truth would later be described by those close to her as an agonizing process of reconciling her love for her son with her legal training, her moral compass, and the overwhelming evidence of his guilt. Friends reported that Patricia became increasingly withdrawn and troubled as trial approached, struggling with depression and what her therapist would later identify as moral injury from knowing the truth about her son's actions while feeling obligated to support him. The breaking point came during a pretrial conference in the judge's chambers, approximately 1 month before trial was set to begin. Defense attorney Charles Morrison had requested the meeting to discuss potential plea arrangements, and Patricia had attended as Brandon's parent and as someone with legal expertise who could help evaluate any offers. The prosecutor, Assistant State's Attorney David Chen, had offered a plea deal. Brandon would plead guilty to second-degree murder in exchange for a sentence of 25 to 30 years in prison, with credit for time served and possibility of parole after serving 85% of the sentence. When Morrison presented this offer to Brandon in Patricia's presence, Brandon's response was dismissive and shocking even to his own mother. "I'm not pleading guilty to anything," Brandon had said. "There's no physical evidence directly tying me to anything. They can't prove I was the one who killed him. That bat could have been used by anyone. My DNA being at the scene doesn't mean anything. We were friends. My DNA would be on things he touched all the time. This is all circumstantial, and a jury will see that." Morrison had patiently explained that the evidence was far from merely circumstantial, that the combination of digital evidence, forensic evidence, and witness testimony created an overwhelming case for guilt, and that refusing this plea offer meant risking a first-degree murder conviction that would carry a sentence of life without parole. Brandon's response, according to Patricia's later testimony, was, "Then I guess we go to trial. I have faith in the system, and I have faith that a jury will see I'm not the kind of person who could do something like this." It was during this exchange that Patricia Harrington realized her son genuinely believed he would be acquitted, not because he was innocent, but because he believed his intelligence, his background, and his family's resources made him essentially untouchable. She later described this as the moment she understood that everything the prosecution had said about Brandon's narcissism and lack of remorse was accurate. Her son wasn't just failing to take responsibility for killing his best friend, he genuinely believed he was above consequence. The trial of State of Illinois versus Brandon Harrington began on April 15, 2024, in DuPage County Circuit Court before Judge Patricia Thornton. The case had attracted significant media attention throughout Illinois and had even garnered national coverage due to the defendant's age, the privileged community where the crime occurred, and the shocking nature of a teenage boy killing his best friend over academic jealousy. The courtroom was filled to capacity each day, with overflow crowds gathering in the courthouse corridors to await updates. Jury selection took 4 days, with both sides carefully vetting potential jurors for their ability to fairly judge a teenage defendant, their views on privileged youth and entitlement, and their capacity to weigh extensive scientific and digital evidence. The final jury consisted of 7 women and 5 men, ranging in age from 28 to 67, representing diverse professional backgrounds and geographic areas within DuPage County. In her opening statement, Prosecutor David Chen laid out the case against Brandon Harrington with methodical precision. Ladies and gentlemen, this case is about a young man who believed he was entitled to success, admiration, and achievement without effort, and who responded with deadly violence when confronted with someone who possessed the qualities he lacked through hard work and genuine character. Brandon Harrington didn't kill Ethan Webb in a moment of passion or impulsive rage. He planned it, executed it, and felt no remorse afterward because, fundamentally, he believed he had the right to eliminate anyone who made him look bad by comparison. Chen displayed the timeline of events on the courtroom's projection screen. The text message luring Ethan to the preserve, Brandon's arrival 15 minutes early, the attack, the attempted concealment of the body, Brandon's calm exit from the preserve, and his normal behavior in the hours and days afterward. The evidence will show that everything Brandon Harrington did that night was calculated. He chose the location. He brought the weapon. He sent the message designed to ensure Ethan would meet him alone. And afterward, he went home, posted on social media about his productive day, and carried on as if nothing had happened. The prosecutor then addressed what he anticipated would be a central theme of the defense's case. You will hear that Brandon Harrington was under pressure, that he was stressed about college applications, that he felt inadequate compared to his friend. You may even feel sympathy for a teenager struggling with these pressures. But you must distinguish between understanding why someone feels certain emotions and excusing what they choose to do about those emotions. Brandon Harrington chose violence. He chose murder. And the evidence will show beyond any reasonable doubt that he is guilty of first-degree murder. Defense attorney Charles Morrison faced the difficult task of defending a client whose own behavior and personality made him deeply unsympathetic. Morrison's strategy focused on attacking the prosecution's claim of premeditation, arguing instead that what occurred at the nature preserve was the result of an argument that escalated to violence, with Brandon panicking and trying to cover up what he'd done, rather than coldly planning a murder in advance. Brandon Harrington is a 17-year-old kid who made a terrible, irreversible mistake, Morrison told the jury. He's not a cold-blooded killer. He's a teenager who was drowning under impossible expectations, who felt like he was losing his identity and his future, and who, in a moment of rage and poor judgment, did something he can never take back. The prosecution wants you to see internet searches and careful planning. What you'll actually see is a confused, desperate teenager having dark thoughts, and then, in a moment of confrontation with his friend, losing control. Morrison acknowledged that Brandon's behavior after Ethan's death was difficult to understand and troubling, but argued that this reflected psychological dissociation and denial rather than lack of remorse. Brandon's mind couldn't process what he'd done, so he continued with normal routines as a defense mechanism. His apparently callous behavior wasn't because he didn't care. It was because he cared so much that his only way to cope was to block it out entirely. The prosecution's case unfolded over 3 weeks, with witnesses and evidence creating a comprehensive narrative of premeditation, violence, and calculated cover-up. The testimony of David and Sarah Webb, both doctors accustomed to maintaining composure in difficult situations, proved emotionally devastating as they described their son's character, his friendship with Brandon, and the impact of his murder on their family. Sarah Webb's testimony about the evening Ethan left to meet Brandon was particularly powerful. Ethan showed me the text message from Brandon, she recalled, her voice steady but strained. He was happy that Brandon wanted to talk and work things out. He said, "Mom, Brandon's been my best friend since kindergarten. I can't just give up on him because he's going through a hard time." I told him I was proud of him for being such a good friend. I encouraged him to go. Her voice broke at this point. I sent my son to meet his murderer, and I told him I was proud of him for doing it. David Webb's testimony focused on Ethan's character and accomplishments, not to boast, but to help the jury understand who had been taken from the world. Ethan wasn't perfect, David told the jury. He was a teenager who sometimes forgot to take out the trash, who occasionally got frustrated with his little sister, who stressed about tests and worried about the future. But he was fundamentally good. He volunteered at the food pantry not because it looked good on college applications, but because he genuinely cared about helping people. He stood up for kids who were being bullied even when it wasn't popular. He was the kind of person who made the world better just by being in it. The medical examiner's testimony provided clinical detail about the violence of the attack. Dr. Robert Chen described the multiple skull fractures, the evidence of continued beating after Ethan was already incapacitated, and the determination that Ethan had likely been conscious for the first several blows before losing consciousness. The injuries pattern shows at least 7 separate impacts, Dr. Chen explained. The first blow, delivered to the back of the head, would have caused immediate disorientation and likely collapse. The subsequent blows, delivered while the victim was on the ground, show continued attack beyond what was necessary to cause death. The forensic evidence presentation consumed several days of trial, with experts walking the jury through the shoe print evidence, the blood evidence on the baseball bat, the DNA matches, and the timeline established through digital forensics. Each piece of evidence was presented methodically, with the prosecution building a comprehensive picture of overwhelming physical proof of Brandon's guilt. The digital forensics testimony proved particularly damaging to the defense. Expert witness Dr. Sarah Martinez, a specialist in digital evidence recovery and analysis, explained how she had extracted data from Brandon's devices despite his attempts to delete search history and messages. Using enlarged screenshots displayed on courtroom monitors, Dr. Martinez walked the jury through Brandon's internet searches, from the early queries about dealing with jealousy and competition to the later, more sinister searches about methods of killing and avoiding detection. The progression of searches shows a clear evolution of thought, Dr. Martinez testified. Initially, we see searches about normal teenage concerns, feeling inadequate, dealing with competition, college stress. But by mid-November, the searches become darker and more specific. Research about the nature preserve, questions about security cameras, queries about how long various methods of killing take. This isn't idle curiosity or research for a school project. This is someone gathering information for a specific purpose. The testimony about Brandon's social media activity after the murder created visible reactions among jurors. Seeing the Instagram post from November 28th, Brandon, smiling over his dinner, captioned "Perfect end to a productive day." Posted just 3 hours after he had beaten his best friend to death, several jurors appeared shocked and disturbed. One juror was observed shaking her head slowly, her expression conveying disbelief at the defendant's callousness. Throughout the prosecution's case, Brandon's courtroom behavior continued to undermine his own defense. He was observed multiple times appearing bored, checking his watch, and whispering what appeared to be jokes to his attorneys during serious testimony. When Sarah Webb broke down crying while describing the last conversation she had with Ethan, Brandon was seen rolling his eyes, an action captured by a courtroom sketch artist, and later featured prominently in news coverage of the trial. Perhaps most damaging was Brandon's reaction during the medical examiner's testimony about Ethan's injuries. When Dr. Chen was describing the fatal skull fractures in technical detail, Brandon let out what multiple observers described as a quiet laugh or scoff. Judge Thornton immediately called for a sidebar, during which she apparently warned Brandon's attorneys that their client's behavior was prejudicing his case and needed to stop immediately. When proceedings resumed, Brandon appeared more controlled, but the damage had been done. The jury had witnessed behavior that suggested not just lack of remorse, but active contempt for the proceedings and the victim. The defense's case lasted only 1 week, reflecting the limited options available given the strength of the prosecution's evidence. Morrison called several witnesses designed to humanize Brandon and provide context for his psychological state, including teachers who described him as a generally good student under significant pressure, former friends who testified about his stress levels, and the school counselor who discussed his anxiety and depression. The defense's expert witness, Dr. Michael Thompson, a psychologist specializing in adolescent development, testified about the teenage brain's limited capacity for impulse control and consequence assessment. The prefrontal cortex, responsible for executive function and decision-making, is not fully developed until the mid-20s, Dr. Thompson explained. Teenagers, even high-functioning 17-year-olds like Brandon, are neurologically more prone to impulsive decisions and less able to fully comprehend long-term consequences of their actions. On cross-examination, Prosecutor Chen methodically dismantled the impulsivity argument by walking Dr. Thompson through the evidence of planning, The days of internet searches, the text message luring Ethan to an isolated location, the weapon brought from home, the attempted cover-up afterward. Dr. Thompson, does the impulsive teenage brain you've described conduct days of research about crime scene investigation and security camera coverage before acting impulsively? Chen asked. The expert had to concede that such planning was inconsistent with pure impulsivity. The defense's decision about whether to put Brandon himself on the stand generated intense debate within the legal team. Morrison and his associates recognized that Brandon's personality and lack of apparent remorse made him an extraordinarily risky witness. However, Brandon himself insisted on testifying, apparently convinced that his intelligence and ability to articulate his perspective would persuade the jury of his innocence, or at least create reasonable doubt. Against his attorney's better judgment, Brandon Harrington took the witness stand on May 7, 2024. His testimony would prove to be the most dramatic and self-destructive portion of the trial, confirming every negative characterization the prosecution had made about his character while providing no effective counter to the evidence of his guilt. Under friendly questioning from Morrison, Brandon attempted to present himself as a good student and friend who had been struggling under enormous pressure. He described his parents' expectations, the stress of college applications, and his feelings of inadequacy when comparing himself to Ethan. I felt like no matter what I did, Ethan did it better, Brandon testified, and everyone noticed. Teachers, parents, other students. They all acted like Ethan was perfect, and I was just okay. It felt like I was disappearing, like I didn't matter anymore. When Morrison asked Brandon to describe what happened at the nature preserve, Brandon's account differed significantly from the prosecution's narrative in ways that the physical evidence would not support. According to Brandon, he had indeed suggested they meet to reconcile, but when they met on the trail, Ethan had started accusing me of being jealous and pathetic. Brandon claimed that Ethan had pushed him, causing him to fall, and that he had grabbed the baseball bat from his backpack to defend myself when Ethan came at me again. I was scared, Brandon testified unconvincingly. I swung the bat and hit him. He fell down. I hit him a couple more times because I was panicking and didn't know what else to do. Then I realized what I'd done, and I didn't know what to do. So I tried to hide what happened and went home. I was in shock. I couldn't process what had happened. This testimony contradicted the physical evidence in multiple ways that the prosecution would enthusiastically highlight on cross-examination. The medical examiner had testified that Ethan's injuries showed he was hit from behind initially, not face-to-face in a defensive struggle. There were no injuries to Brandon consistent with having been pushed or having fallen, and the number and severity of the blows indicated continued attack far beyond what any defensive action would require. More problematic was that Brandon's testimony on direct examination failed to explain the internet searches, the selection of an isolated meeting location, or his complete lack of emotional response in the days after Ethan's death. Morrison had carefully avoided these topics during direct examination, hoping they wouldn't be raised, but knowing that cross-examination would be devastating. Prosecutor David Chen's cross-examination of Brandon Harrington would later be described by legal observers as a masterclass in destroying a defendant's credibility. Chen began quietly, almost sympathetically, asking Brandon about his relationship with Ethan during their childhood, establishing that they had been genuinely close friends. Then, slowly and methodically, Chen began highlighting the contradictions between Brandon's testimony and the evidence. Brandon, you testified that you brought the baseball bat to the preserve to show Ethan because you were planning to play in an alumni game, Chen began, referencing Brandon's explanation for why he had the bat. But you graduated from middle school baseball 4 years ago, and there's no alumni game scheduled. That was a lie, wasn't it? Brandon struggled to respond, eventually claiming he had misremembered the reason he had the bat. Chen then moved to the internet searches, projecting them on the courtroom screen one by one. Brandon, on November 23rd, 5 days before you killed Ethan, you searched, "How long does it take to die from blunt force trauma to head?" Can you explain why you were researching this? Brandon claimed it was random curiosity, and that he had probably seen something on TV that made him wonder. Random curiosity, Chen repeated, letting skepticism color his tone. On November 24th, you searched Lakewood Nature Preserve security camera coverage. Was that also random curiosity? Brandon's answers became increasingly defensive and implausible as Chen walked through search after search, each one demonstrating planning and premeditation. The cross-examination reached its climax when Chen addressed Brandon's behavior after the murder. Brandon, you testified that you were in shock after Ethan died, that you couldn't process what happened. Is that correct? Brandon confirmed this was his testimony. Chen then displayed the social media post from the evening of November 28th, the photo of Brandon's dinner with the caption about a productive day. Does this look like someone in shock who can't process what happened? Chen asked. Or does this look like someone who killed his friend and felt good about it? Brandon's response, "I was just trying to act normal," rang hollow given the upbeat tone of the post. Chen then played video clips from security cameras at the preserve parking lot, showing Brandon's casual demeanor as he left after the murder. "Is this what shock looks like?" Chen asked. "You're checking your phone, walking normally, no visible distress. This doesn't look like someone who just killed their best friend in a tragic accident. This looks like someone who did exactly what they planned to do and is calmly leaving the scene." The most damaging moment of cross-examination came when Chen asked Brandon directly about remorse. "Brandon, do you feel sorry for what you did to Ethan?" The question hung in the courtroom, with every juror leaning forward to hear the response. Brandon's answer would be replayed countless times in media coverage and would cement his fate with the jury. "I feel sorry about how everything turned out," Brandon said carefully, his tone suggesting he had rehearsed this response. "Obviously, I wish Ethan hadn't died. But I also feel like if he had been a better friend, if he had understood what I was going through instead of just making everything about himself and his achievements, maybe none of this would have happened." This response, blaming Ethan for his own murder, created audible gasps in the courtroom gallery. Several jurors appeared visibly shocked. Judge Thornton, her face a mask of professional neutrality, had to gavel the courtroom back to order. Chen, recognizing that Brandon had just destroyed any remaining sympathy the jury might have had, simply responded, "No further questions, Your Honor." Brandon's testimony had accomplished what the prosecution alone could not. It had revealed to the jury exactly who he was: a narcissistic, entitled teenager utterly lacking in empathy or remorse. Someone who believed he was the victim even though he had taken another person's life. Morrison's redirect examination attempted to rehabilitate Brandon's testimony, but the damage was irreparable. The defense rested shortly after, having accomplished nothing but confirming the prosecution's characterization of the defendant. The closing arguments took place on May 10, 2024. Prosecutor Chen's closing was a powerful synthesis of the evidence, the testimony, and Brandon's own words. Ladies and gentlemen, you have seen the evidence. You have heard Brandon Harrington's own testimony. He has shown you exactly who he is. Not a scared teenager who made a tragic mistake, but a calculating killer who planned his best friend's murder, executed it, and felt no genuine remorse afterward. He blamed Ethan just moments ago for his own death. That tells you everything you need to know about Brandon Harrington's character and his guilt. Morrison's closing argument emphasized reasonable doubt and the possibility that what occurred at the preserve was a fight that escalated tragically, not a premeditated murder. The prosecution wants you to see a monster, but what you're really seeing is a 17-year-old kid who made the worst decision of his life in a moment of rage and poor judgment. Yes, his behavior afterward is troubling. Yes, his testimony raised questions. But that doesn't prove first-degree murder. It doesn't prove that he went to that preserve planning to kill his friend. The jury began deliberations on May 11, 2024. Unlike some high-profile cases where deliberations stretch for days, the Brandon Harrington jury reached a verdict in less than 5 hours. Court personnel later reported that the brevity of deliberations suggested the jurors found the evidence overwhelming and required little time to reach consensus. When the jury returned to the courtroom at 4:47 p.m., Brandon appeared remarkably unconcerned, reportedly whispering to his attorney that 5 hours is nothing. They probably spent most of it on lunch. This confidence would prove to be catastrophically misplaced. In the matter of State of Illinois versus Brandon Harrington, on the charge of first-degree murder, we the jury find the defendant guilty as charged. The courtroom remained silent for a moment after the verdict was read, the weight of the conclusion settling over everyone present. Then, from the Webb family's section in the gallery, Sarah Webb began to cry, her husband's arms around her as they processed that justice had been delivered for their son. Brandon's reaction was initially one of apparent disbelief, his confident smirk fading as the reality of the verdict penetrated his denial. Then, in a moment that would be widely reported and would influence his sentencing, Brandon turned to his attorney and said, loudly enough to be heard by nearby court personnel and reporters, "This is bullshit. These people are idiots. My parents' attorneys will handle this on appeal." Judge Thornton, her patience with Brandon's attitude finally exhausted, immediately addressed him. "Mr. Harrington, you have been convicted by a jury of your peers of first-degree murder. I suggest you show respect for this verdict and for these proceedings, or I will hold you in contempt." Brandon's response was to scoff and shake his head, muttering under his breath in a way that court observers interpreted as continuing his dismissive attitude. Judge Thornton set sentencing for June 15, 2024, 1 month after the verdict, allowing time for preparation of presentence investigation reports and victim impact statements. As Brandon was led from the courtroom in handcuffs, his earlier confidence had been replaced by visible anger and disbelief. His face flushed as he apparently struggled to accept that he would not be going home that evening, or any evening in the foreseeable future. The month between verdict and sentencing proved transformative for Patricia Harrington, Brandon's mother. Friends and colleagues later described this period as when Patricia finally confronted the full truth about her son and made the agonizing decision that would shock the courtroom and seal Brandon's fate. Until the verdict, Patricia had maintained her support for Brandon, convincing herself that the evidence was circumstantial, that there must be reasonable doubt, that her son couldn't possibly have done what the prosecution claimed. The verdict shattered this denial, forcing Patricia to acknowledge that a jury had found beyond reasonable doubt that Brandon had planned and executed Ethan Webb's murder. More significantly, witnessing Brandon's behavior during trial, his smirking, his eye-rolling, his victim-blaming testimony, had opened Patricia's eyes to aspects of her son's character that she had previously excused or ignored. The realization that she had raised a child capable of murder and utterly lacking in remorse created what her therapist would later describe as a moral crisis. Patricia spent the weeks before sentencing reviewing trial transcripts, examining evidence she had previously viewed through the lens of maternal defense, and confronting the uncomfortable truth that her parenting approach may have contributed to Brandon's character defects. Her emphasis on achievement over character, her dismissal of mental health interventions when they were recommended, her modeling of aggressive, win-at-all-costs legal tactics. All of these began to appear in a different light as she considered her role in creating the person Brandon had become. The decision to testify at Brandon's sentencing came after extensive consultation with her own therapist, with her priest, and with close friends who had supported her through the trial. Patricia understood that testifying against her son would be seen as betrayal, that it would permanently sever their relationship, and that it would subject her to public scrutiny and judgment. But she also believed that remaining silent would make her complicit in Brandon's continued denial and would dishonor Ethan Webb's memory. The sentencing hearing on June 15, 2024, drew even larger crowds than the trial, with courthouse security implementing special protocols to manage the overflow. The proceeding began with victim impact statements from the Webb family, each one more wrenching than the last as they described the permanent void Ethan's death had created in their lives. David Webb spoke first, his physician's composure barely containing his rage and grief. Brandon Harrington took our son from us for the most petty, pathetic reason imaginable. Because Ethan made him feel inadequate by being a good person who worked hard and treated others with kindness. He killed Ethan and then went home and posted on social media about his productive day. He sat in that courtroom and blamed Ethan for his own murder. I had treated thousands of patients in my career, saved many lives, and I have never encountered someone so devoid of human decency as Brandon Harrington. He should never be free again. Sarah Webb's statement focused on the loss to the world, not just to their family. Ethan wanted to be a civil rights attorney. He wanted to use his skills to help people who couldn't help themselves. He volunteered his time, stood up for the vulnerable, and tried to make the world better in small ways every day. We lost not just a son, but all the good he would have done in the world. Brandon Harrington murdered Ethan, but he also murdered all the people Ethan would have helped, all the positive change he would have created. That's what makes this so unforgivable. Maya Webb, Ethan's younger sister, now 14, delivered a statement that reduced many in the courtroom to tears. "My brother was my best friend and my hero. He taught me how to stand up for myself, how to think critically, how to be brave. I wake up every morning and forget for a second that he's gone. Then I remember, and it feels like being stabbed all over again. Brandon was supposed to be Ethan's friend. Ethan tried to help him, tried to understand what he was going through, and Brandon killed him for it. I will never forgive him." After the Webb family's statements, several of Ethan's teachers, debate team members, and the director of the food pantry where he volunteered delivered statements about his character and the loss his death represented to the broader community. Each statement built on the previous one, creating a comprehensive portrait of a young life full of promise that had been snuffed out by narcissistic rage. Throughout these impact statements, Brandon's demeanor continued to show his inability to grasp the gravity of his situation, or feel genuine empathy for his victims. He appeared bored during some statements, checking his watch repeatedly, and at one point was observed yawning during Maya Webb's emotional testimony. His attorneys repeatedly leaned in to whisper to him, presumably urging him to show appropriate respect, but Brandon seemed unable or unwilling to modify his behavior. Then came the moment that would define the sentencing hearing and ensure maximum punishment for Brandon Harrington. The prosecutor called Patricia Harrington to the stand, a development that shocked everyone in the courtroom, including Brandon himself, who audibly gasped and turned to stare at his mother as she walked to the witness stand. Patricia Harrington, dressed in a simple black suit, her face showing the toll of months of stress and moral anguish, was sworn in and took her seat. Her husband, Thomas Harrington, had not attended the sentencing hearing, reportedly unable to face the courtroom proceedings and opposed to his wife's decision to testify. Patricia was alone as she prepared to deliver testimony that would devastate her son's remaining chance for mercy. Prosecutor Chen began gently, establishing Patricia's credentials as a successful attorney, her reputation in the community, and her role as Brandon's mother. "Ms. Harrington, I understand you have asked to provide testimony today. Can you explain to the court why you felt this was necessary?" Patricia took a deep breath before responding, her voice steady despite the obvious emotional difficulty of what she was about to do. "I am here because I have a moral obligation to tell the truth, even when that truth condemns my own son. I am here because remaining silent would make me complicit in Brandon's denial and his lack of accountability. And I am here because the Webb family and this court deserve to understand who Brandon really is, not the version his defense team has tried to present." What followed was 45 minutes of testimony that methodically dismantled every mitigating argument the defense had made and exposed aspects of Brandon's character and behavior that had been hidden from the court. Patricia, drawing on her legal training and her intimate knowledge of her son, provided devastating insights that no other witness could offer. She described finding Brandon's journal in his bedroom before trial, a journal that his defense team had successfully kept out of evidence through various legal maneuvers. The journal, Patricia testified, contained entries that made clear his hatred for Ethan was long-standing and deep. There were entries from as far back as freshman year, where Brandon wrote about wanting Ethan to disappear, or to fail spectacularly, so everyone would see he's not that great, Patricia testified. I brought this to his defense team's attention, and they decided it was too damaging to ever let prosecutors see it. But this court needs to know that Brandon's hatred of Ethan was not a recent development triggered by temporary stress. It was a pattern going back years. Patricia then addressed Brandon's behavior during trial and afterward. I have watched my son sit in this courtroom, smirking and laughing during testimony about his victim's death. I have watched him show no remorse, no empathy, no understanding of the magnitude of what he's done. I have heard him, in private conversations with his attorneys that he didn't realize I could overhear, describe this trial as annoying, and predict that his conviction would be overturned on appeal because the jury was too stupid to understand the evidence properly. The courtroom was utterly silent as Patricia continued, her testimony gaining power as she spoke. As Brandon's mother, I love him. I will always love him. But as someone who believes in truth and justice, I cannot stand by and watch him manipulate this process or avoid accountability for what he's done. Brandon planned Ethan Webb's murder. He executed it. He felt no remorse afterward, and he blames everyone but himself for the consequences of his actions. Patricia then addressed the most difficult topic, her own role in creating the person Brandon had become. I take responsibility for my part in who Brandon is. My husband and I raised him in an environment where achievement was everything, and where emotional development was neglected. We taught him that success was measured by external validation and comparison to others. We dismissed mental health concerns when they were raised because we were worried about labels and appearances. We modeled aggressive, win-at-all-costs behavior in our own careers. And, in doing so, we created a child who grew into a teenager who believed he was entitled to success, admiration, and achievement without effort, and who responded with violence when confronted with someone who possessed the qualities he lacked. This remarkable act of public self-accountability from a mother about her own parenting failures stunned the courtroom. Patricia continued, "But while I acknowledge my role in contributing to Brandon's character defects, I also understand that many children are raised in imperfect environments and don't become killers. Brandon made choices. He chose violence. He chose murder. And he continues to choose denial and blame rather than accountability and remorse. Those choices are his own, and he must face the full consequences of them." As Patricia's testimony concluded, Brandon's face had transformed from its typical smirk to an expression of shocked betrayal and rage. He began shaking his head violently, muttering loudly enough to be heard, "This is bullshit. You're supposed to be my mother. You're supposed to defend me." Judge Thornton gavelled for order, warning Brandon that he would be removed from the courtroom if he couldn't control himself. On cross-examination, defense attorney Morrison attempted to characterize Patricia's testimony as that of a mother suffering from guilt and depression, not rational assessment of her son's character. but Patricia held firm, answering each question with the precision and credibility of an experienced attorney. Morrison's attempts to discredit her testimony only reinforced how powerful and damaging it was, a mother who loved her son but loved truth more. After Patricia stepped down from the witness stand, the defense presented their sentencing arguments, focusing on Brandon's youth and the possibility of rehabilitation over decades of incarceration. But the impact of Patricia's testimony had fundamentally shifted the courtroom dynamic. Her willingness to acknowledge her son's guilt and his lack of remorse, despite the personal cost, gave Judge Thornton the validation she needed to impose maximum punishment. Judge Patricia Thornton, addressing the court before announcing sentence, referenced Patricia Harrington's testimony directly. "In my 15 years on the bench, I have never witnessed a parent testify against their own child in the manner we just observed." Ms. Harrington's testimony was devastating to her son's case, but it was also an act of profound moral courage. She understood that being a parent doesn't mean enabling denial or protecting a child from deserved consequences. It means demanding accountability, even at tremendous personal cost. Judge Thornton then addressed Brandon directly, her tone severe and uncompromising. "Mr. Harrington, you murdered your best friend out of jealousy and narcissistic rage. You planned his death, executed it with brutal violence, and showed no genuine remorse afterward. Throughout this trial and even during this sentencing hearing, you have demonstrated contempt for these proceedings, for your victim, and for the truth. Your own mother, an attorney who understands the law and who loves you despite your actions, has testified that you are manipulative, lacking in empathy, and fundamentally unaccountable for your choices." The judge continued, "I have considered your age, your background, and the psychological evaluations submitted on your behalf. I have considered the defense's arguments about your potential for rehabilitation. But I have also considered the premeditated nature of your crime, your consistent lack of remorse, your victim blaming even in your own testimony, and your behavior throughout these proceedings. Most significantly, I have considered your own mother's testimony about who you truly are beneath the defense your attorneys have tried to construct." Judge Thornton then pronounced sentence. Brandon Michael Harrington, for the murder of Ethan David Webb, this court sentences you to life in prison without the possibility of parole. The law provides for juvenile offenders to receive sentences that acknowledge their age and capacity for change. But the law also recognizes that some crimes, committed by some offenders, warrant the most serious punishment regardless of age. This is such a case, and you are such an offender. The sentence, the harshest possible under Illinois law, reflected the judge's assessment that Brandon represented a continuing danger and that his complete lack of remorse made rehabilitation unlikely. Brandon's reaction to the sentence was a mixture of disbelief, rage, and, finally, for the first time in the entire proceedings, something that might have been fear, as the finality of his situation penetrated his narcissistic shield. As deputies approached to lead him from the courtroom, Brandon stood and turned toward the gallery where his mother sat. His final words, shouted loud enough for the entire courtroom to hear, demonstrated that even in this moment of ultimate consequence, he remained unable to accept responsibility. "This is your fault. You did this to me. You're supposed to be my mother and you destroyed me. I'll never forgive you for this." Patricia Harrington, tears streaming down her face, responded in a voice loud enough to carry across the courtroom. "I didn't destroy you, Brandon. You destroyed yourself. And you destroyed Ethan. I love you, but I can't protect you from the truth anymore." As Brandon was led from the courtroom, still shouting accusations at his mother, the Webb family embraced, their relief at the sentence mingling with the permanent grief of their loss. Patricia Harrington sat alone in the gallery, her face buried in her hands, having made the most difficult choice a parent can make and having to live with its consequences for the rest of her life. The aftermath of Brandon Harrington's sentencing rippled through multiple communities and raised profound questions about parenting, privilege, adolescent violence, and the criminal justice system's capacity to address juvenile offenders who demonstrate adult-level calculation and complete lack of remorse. The case became a frequent reference point in discussions about wealthy families, parental accountability, and the importance of character development alongside academic achievement. In Lakewood, the community grappled with the reality that such violence had emerged from their affluent, seemingly well-adjusted population. Lakewood High School implemented enhanced mental health resources, mandatory social-emotional learning curricula, and programs specifically designed to address perfectionism, competition, and unhealthy comparison among students. The school's guidance counselors reported significant increases in students seeking help for anxiety and depression, suggesting that the case had opened conversations about mental health that had previously been suppressed by the community's focus on success and achievement. The Ethan Webb Memorial Scholarship was established by his parents, providing annual awards to students who demonstrated not academic excellence alone, but a combination of achievement, character, service to others, and commitment to making positive contributions to their communities. The scholarship deliberately emphasized that character matters more than accomplishment, directly countering the values that had motivated Brandon's violence. For the Webb family, life after sentencing meant learning to carry their grief while honoring Ethan's memory through positive action. David Webb reduced his clinical practice to focus more on teaching and mentoring young doctors, viewing this as continuing his son's commitment to helping others. Sarah Webb became involved with victim advocacy organizations, supporting other families navigating the criminal justice system after losing loved ones to violence. Maya Webb, now in high school herself, channeled her grief into debate, team, and social justice work, carrying forward her brother's legacy of standing up for others. Patricia Harrington's life was permanently altered by her decision to testify against her son. Her law practice suffered as some clients, uncomfortable with her public acknowledgement of parenting failures, sought other representation. Her marriage to Thomas Harrington ended in divorce within 6 months of Brandon's sentencing, with Thomas unable to forgive his wife's testimony and unwilling to accept responsibility for his own role in their son's development. Friends reported that Patricia experienced significant depression and underwent intensive therapy to process the complex grief of losing her son to prison, while also acknowledging he deserved his punishment. However, Patricia also found unexpected purpose in her experience. She began speaking at legal and parenting conferences about the dangers of achievement-focused parenting that neglects emotional development, about the importance of accountability over enabling, and about the moral responsibility parents have to acknowledge truth even when it devastates them personally. Her willingness to discuss her failures publicly, while painful, helped other parents recognize warning signs in their own families and seek help before crises developed. Brandon Harrington's first years in the Illinois Department of Corrections system were marked by continued denial, rage at his mother's betrayal, and minimal participation in available programs or therapy. Prison psychological evaluations continued to note his narcissistic features, his external locus of control, and his inability to take genuine responsibility for his actions. Reports from correctional officers indicated that Brandon spent considerable time writing appeals and complaints, convinced that his conviction would be overturned and that he would eventually be vindicated. His appeals, filed by new attorneys after Charles Morrison withdrew from representation, argued that the trial court had erred in allowing Patricia Harrington's testimony, that Brandon's youth should have precluded a life sentence without parole, and that pretrial publicity had tainted the jury pool. The Illinois Appellate Court rejected these arguments in 2026, finding that Patricia's testimony was properly admitted, that the sentence was appropriate given the premeditated nature of the crime and Brandon's complete lack of remorse, and that voir dire had adequately addressed pretrial publicity concerns. By his early 20s, prison records showed subtle shifts in Brandon's presentation, though whether these represented genuine development or learned behavior designed to improve his appeal, prospects remained unclear. He began participating in educational programs, completed college courses through distance learning, and started attending some therapy sessions. Counselors reported that he had begun, very tentatively, to acknowledge some responsibility for his actions, though he continued to frame his crime primarily in terms of how it had affected him rather than its impact on his victim. In a prison interview conducted in 2028, 4 years after his sentencing, Brandon discussed his mother's testimony for the first time publicly. "I was devastated when my mom testified against me," he stated. "I felt betrayed and abandoned. But I've had time to think about what she said, and I can see now that she was telling the truth about who I was at that time. I don't know if I'm different now. I hope I am. But I understand why she felt she had to do what she did, even though it still hurts." This interview, published in a criminal justice journal, sparked renewed debate about juvenile offenders, rehabilitation potential, and the appropriate role of family members in criminal proceedings. Some viewed Brandon's statements as evidence of growth and self-awareness, supporting arguments for eventual parole consideration. Others saw his comments as calculated manipulation designed to improve his public image and support future clemency requests. The question of whether Brandon Harrington would ever be released from prison remained, as of 2030, largely academic. His life sentence without possibility of parole meant he would die in prison absent commutation or pardon. Prospects that seemed unlikely given the circumstances of his crime and his well-documented lack of remorse during trial and sentencing. Any future governor who considered clemency would have to confront extensive documentation of Brandon's behavior, including his own mother's testimony about his character and his victim-blaming statements in court. What remained clear was that multiple lives had been destroyed by Brandon's actions on November 28, 2023. Ethan Webb would never realize his potential, never attend college, never become the civil rights attorney he had dreamed of being, never make the positive contributions to the world that those who knew him believed he would have made. The Webb family would carry their grief permanently, navigating holidays, milestones, and everyday moments shadowed by Ethan's absence. Brandon Harrington would spend his youth, his middle age, and eventually his old age in prison, paying the maximum price for his decision to respond to jealousy with murder. His parents' marriage had ended. His mother had been forced to choose between enabling her son's denial and honoring truth, and the future they had envisioned for their family had evaporated entirely. The case of Brandon Harrington serves not as a simple morality tale with clear lessons, but as a complex examination of how privilege, parenting, narcissism, and adolescent brain development can intersect to create tragedy. It demonstrates the importance of character education alongside academic achievement, the dangers of parenting approaches that emphasize external validation over internal development, and the critical need to take seriously warning signs of emotional and psychological dysfunction in teenagers. Most powerfully, Patricia Harrington's decision to testify against her son, despite the personal cost, stands as a profound example of moral courage and the recognition that true love sometimes requires demanding accountability, rather than providing protection from deserved consequences. Her testimony ensured that Brandon would face full punishment for his crime, but it also modeled for other parents the difference between supporting a child and enabling their denial. The courtroom where Judge Thornton pronounced Brandon's sentence now handles routine criminal matters. The nature preserve where Ethan Webb died has been renamed the Ethan Webb Memorial Preserve, with a plaque near the parking lot reminding visitors of his character and encouraging them to treat others with the kindness he exemplified. But the questions raised by this case about privilege, accountability, parenting, and justice continue to resonate, ensuring that both Ethan Webb's promise and Brandon Harrington's narcissistic violence remain subjects of discussion and reflection for those seeking to understand how teenage friendship can turn to murder when empathy, character, and accountability are absent.